Can I sell items made from a pattern? Or can I forward a free pattern to a friend? Or how about help? Can I post a screenshot of a pattern online so others may help me? Or how about my stash? Can I sell unused old yarn? Well, a lot of knitters may not even be aware that they're facing challenging legal questions with every stitch they knit, with possibly very expensive consequences. So in this video, I want to address this very important and often overlooked topic so you may knit with confidence. Let's dive right into it. First question, can I forward a pattern or a free pattern to my friend? The answer is, in most cases, probably no, you can't. Typically, you are not allowed to create copies of about anything and share them with a third party, especially not commercially, except you have a license to do so. But before I go on, I absolutely need to add a disclaimer here, and I probably also need to remove my shawl here because it's remarkably hot today. Anyway, my disclaimer here is I am not a lawyer, I am a knitter, and if you need a legal advice, absolutely contact one. Why? Because I am here in Austria, you may be in a different country, and the designer may be in yet another different country. And your specific case might be different in one minor but very important aspect. And neither I nor a YouTube video in general are suitable to answer your specific case. That being said, in the days of the internet and global trade, copyright law is remarkably uniform. So there are definitely some general themes we can talk about. They cannot, of course, replace proper legal counsel. But back to the pattern question. So typically what happens in your family under one roof is okay. Say your grandma or your daughter is living in your house, well then you are probably both allowed to read and knit the same pattern. You don't need to buy two patterns. And you are probably even allowed to create one or two copies so you can both read it at the same time. Or maybe you want a copy for yourself so you can add notes on the margins without spoiling the original. That's typically perfectly fine and often actually a very smart move. But making a copy of the pattern and giving it to your neighbor or your great-grandniece, well, that's typically something you might want to avoid. If it's just a pattern book or a magazine and you are not running this on a commercial scale, you can typically lend it out for free, donate it, or resell it. This is called the first sale doctrine in the US. But then during the duration of said transaction, you will not or no longer have access to the pattern. With a digital pattern, that's typically not possible. As soon as you send out that email with an attachment, you are creating a digital copy of something while the original PDF or a picture, whatever it is, remains in your possession, and that is typically a copyright infringement. And if you then if you then delete it, there will always be a short amount of time where two illegal copies existed. The only exception here are historic books. For example, in the United States, if the book was first published before January 1st, 1978, and all renewals were filed properly, the copyright typically expires 95 years after the author's death. And once this happens, these files may probably be shared digitally as well, so this concerns historic knitting patterns. For works published after 1978, it's typically 70 years. And that is not even all that obscure. There are tons of historic knitting pattern books you can access through various online archives. There's even a knitting library, and so you can access and share these for free, and that is quite a beautiful opportunity for those interested in historic patterns. But let's take a different point of view here. Take my case, for example. It takes me hours to compile a pattern, do the layout, do the test knitting, take all the pictures. A lot of effort and creativity goes into it, and the law recognizes this. You cannot simply copy another person's work without asking them, just because it's easy to attach a PDF to an email. Unlike other works of art, say sculpture or painting, where you probably wouldn't even think of it. But Norman, the pattern was for free, what's the big deal? Well, there are typically very specific reasons why a designer decides to share a pattern for free. In my case, I want you to join my newsletter. Others want visits to their website or their shop and so on. And if you forward a free pattern, then that never happens. Now I know there are those that will say, and I've heard this argument countless times, well, they still see the pattern and if they like it, they will buy a pattern later on. So I'm helping to spread the word. Setting aside that it's probably still a copyright infringement, the just as important bit here is that people that only knit free patterns, and there's nothing wrong with that, the people that typically just knit free patterns are very unlikely to do that, and they rarely Google the designer's name to follow them on Instagram. And if they do, they typically do it to receive even more free patterns. Setting that aside, think of it like this. Maybe there is this special event at your local mall and everyone that comes to a specific shop gets, a free cotton bag. Now, what would happen if you go to that store and grab 20 cotton bags for all of your friends? Well, they would probably say no or be very annoyed. The reason they gave away these bags for free was the hope that you check out their shop and maybe buy something. Thus, they make more money than the cotton bags would cost. But if you distribute those bags, that doesn't work. The result, they probably won't do it again. And with pattern designers, it's the same. If they notice that giving away their patterns for free doesn't make any sense for them, they will not repeat it. So forwarding a free pattern instead of the link where others may obtain that pattern is basically a way to ensure there will be no more free patterns from that designer. And if it's a paid pattern, the same applies. Designers need to make a living. I have a full episode here on YouTube that deals with that specific problem. I'll link it to you up in here. If selling patterns cannot pay your bills, well, then you have to stop doing them. Thank yous and likes cannot buy food or pay the rent. That is one of many reasons why I have a Patreon account. My channel is definitely not small anymore, probably one of the biggest knitting channels here on YouTube. Still, I definitely don't earn enough through ads to make a living. And here in Austria, 50% of what I earn is tax, mandatory health insurance, and so on. And as much as I love knitting and sharing all that I knit with you, I cannot escape the realities of life. So if you like my work and you would like to ensure that I am in a position to continue doing what I do, creating free patterns, tutorials, and everything else that is here on my YouTube channel, definitely consider becoming a patron. Otherwise, there may come a day where I say, well, I have to find work elsewhere. And if you look around, this has happened to a lot of other knitting channels before. And the same applies to the other designers as well, and I specifically want to highlight them here as well. If you like their work, support them in every way possible. Even as it is, most knitting designers make a pittance with their patterns. You may think $4.99 for a pattern is a lot, and maybe for you it is. But in a lot of cases, these prices are barely feasible, and probably it should be more like $9.99 or $12.99. And every time you forward a pattern, setting the copyright infringement aside, every time you forward a pattern, you are basically taking away the little that they have, and then you are left with the same old patterns and the same repetitive patterns from the same very selected few designers that are highly successful. The second question I receive a lot is, Norman, I love your cute little pumpkins, mushrooms or hearts. Can I knit a couple and sell them at the local fair? Absolutely. In all my current patterns, you will find a little paragraph at the very end that clearly states that small business owners are welcome to sell finished items based on my patterns, and that of course includes you. But what about other designers? There are two things we need to look at. First of all, in most Western countries, knitting instructions, I'm not talking about the text and not the pictures, but knitting instructions do not fall under the copyright or can be protected by a patent. While there are ways to register one in certain very specific cases, typically that is not possible or not the case. And the reason behind that is very simple. We all want to knit sweaters, socks or hats and wear these useful items. And if one person was able to, hold the rights for plain vanilla socks or something like that, then this quickly would become very difficult. And as a result, you can typically use such a pattern and sell items made from it, except there is a patent. In an interesting US Supreme Court ruling, Baker versus Selden, it says, and I need to read this, the very object of publishing a book on science or the useful arts is to communicate to the world the useful knowledge which it contains. But this object would be frustrated if the knowledge could not be used without incurring the guilt of piracy of the book. And then the use of the art is a totally different thing from a publication of the book explaining it. So basically, copying is not possible, using it should be. I want to specifically mention in the context that we are talking about the actual instructions, so knit one, purl one. The individual pictures and the specific wordings typically fall under the copyright as detailed before. And in that context, there is a second legal aspect you might want to consider. Imagine, let's say in the pattern on page 20, it says you are not allowed to sell items, finished items based on this pattern. Well, fine. But if you were not able to know this at the point of sale, then this sentence is basically moot. Imagine you specifically bought this pattern because you wanted to sell the items based on this pattern, and then it says you can't. Well, you probably would be disappointed, right? So unless there is a specific checkbox you have to check before you buy the pattern, and it says, I am aware that I will not be able to sell finished items based on this pattern, you can typically ignore these warnings, well, at least from a legal point of view. If it's a free pattern, one could argue things are a little bit murky because the access to said sentence is a little bit easier or a lot easier, and the contract between you and the designer is also a little bit looser. But even then, if there is no registered patent, and if there is, it should say so in the pattern. So if there is no registered patent, well, it only leaves you with a little bit of a moral dilemma. Still, do keep three things in mind. If you sell items, always add a little link or a fair reference to the designer. That way you ensure that nobody will get the impression that you designed the item. You filled the pattern with your creativity. That's what you did. Secondly, you may still consider contacting the designer with a short message or email. Thank them for their great pattern, because there is a chance that they will help you promote your sales, especially if there is a link or a fair attribution. Stories on Instagram or a post on Facebook basically just take one click for a designer to share, and they often do exactly that when they see something gorgeous. And the third thing you need to consider, if you plan to sell thousands of copies, things might look a little bit different. Possibly not legally, but definitely morally. And ultimately, you may be facing a huge social media backlash, cancel culture, and so on from the loyal community of the designer, and that's never pretty. Issue number 3, asking for help online. Very often I receive emails from fans that need help with a pattern, and very often they also attach the pattern to the email. We already learned that this is probably something you need to avoid. Doesn't matter if it's your neighbor or me as a knitting professional, you are creating a digital copy. Don't forward full patterns. I typically reply in a very strict way that surprises some people that only know my rather gentle side. But hey, this is no joke, especially from a designer's point of view. And this is precisely the reason why I cannot and won't record a tutorial showing you how to knit another designer's pattern. Copyright. Also, on Ravelry, Reddit, Facebook, and so on, I often see how people share screenshots of patterns asking for help. Hey, I don't know what the instructions in row 43 mean. Can somebody help? That's pretty common, and you may have been in a situation before where you need help as well. And here's the deal. In a lot of the countries in Europe, you have something called a small quote. And in the US, you have something similar called the Berne Convention Article 10, where it says, and I need to read this again, it shall be permissible to make quotations provided that their marking is compatible with fair practice and their extent does not exceed that justified by the purpose. A quote typically needs to be clearly marked and fully referenced. This means there should normally be a link to the original pattern, and the reader has to clearly and instantly see and read that whatever they see is not yours but written by or created by the respective author. Typically, that is not the issue. The issue is typically the extent of the quote. This means if you take a screenshot of a page where almost the full pattern is visible or the full pattern is visible, well, that may be convenient to you, but that's not a quote anymore. That's probably a copy. A copy that keeps people from visiting a website, generating ad revenue, or buying a pattern. So under normal circumstances, if you limit the screenshot or quote to the immediate lines surrounding the issue at hand, you are probably okay. But if the quote allows someone else to knit the full pattern or important parts thereof without buying it, well, you may be doing something that is a copyright infringement. So ultimately, the same applies. Link to the pattern and ask your question without copying it. And if more background information is needed, rephrase it. Sure, the 3 pages you share might be important to answer your question, but still, that probably means that the extent of the copy exceeds that justified by the purpose. Since the actual instructions, not the wording of the designer and the pictures, but the actual instructions are probably not protected, you can reword things and rewrite things in your own voice. Sure, it might be more work, but it's probably the legally safer way, and ultimately it might actually help you answering your question yourself. Question number 4. Can I use your pictures in my PowerPoint presentation, seasonal greeting cards, or research paper? I receive remarkably many emails asking for permission to use one or a couple of my pictures. And as you might have seen in a post on the community tab, there are also quite a lot of entities who use my pictures without permission. So what's the deal here? There is something called fair use. It's often quoted and just as often misunderstood. Most Western societies are highly protective of 2 things: the family and research. These 2 things keep our society going, and typically these are areas where copyright is none of your concern. If you print out one of my pictures and put it on the wall of your living room, that's typically perfectly fine. And if you write an academic paper, use one of my pictures and reference me properly, and that is definitely something you should do, because otherwise your peers or prof might do more than just complain. Sure, go ahead. As soon as things get public or commercial, this typically is no longer true. Especially if you earn money with it, you have to acquire a proper license to use this in a commercial or public context. Say you want to post this on social media or an online forum, or I don't know, on your website. And in addition, you have to consider that in the days of social media, the distinction between private and commercial and public is far from easy, especially if your social media profiles are not private but accessible to anyone, and you post with the intention to generate likes and the intention to acquire new followers and reaching a wider audience. That is no longer a private activity. And I specifically want to mention this here because a lot of digital creators are forced to work together with specialized attorneys and automated platforms because this is happening so often. So take my case, there's probably hundreds of websites, commercial entities, yarn shops, and so on that use my pictures for their commercial purposes. So you start working together with automated platforms that automatically send out emails and cease and desist letters and so on. And typically the emails you receive from these attorneys, well, they are not that pleasant anymore, and they're not asking after your health or the current weather anymore. Another question I receive a lot is, can I get a refund for my pattern? I don't want it anymore. Well, this is difficult. Here within the European Union, customers typically have a right to return anything they buy online within 14 days. They have the right to cancel such a contract, and the reason behind that is very simple. If in a store you can try on the shoes, but if you buy them online you can't. But there are quite some exceptions, and patterns typically are among them, and if you think about it, it makes sense. As a designer, the second I send you a pattern, you may read it, knit it, or copy it for private purposes. And if I then refund you, I have no way of knowing whether you consumed it or not. I mean, maybe I have your word, but when it comes to money, people do lie. Not everyone, but more than you think. Often it happens that people buy a pattern and then they notice it's too difficult for them or not what they thought it would be, and then they want to return it. Now, of course, just because you didn't like a movie or didn't like a book doesn't give you the right to return it. But as a designer, I feel if there is a valid reason for the return, I feel one is morally obliged to accept it. If there is a major mistake in the pattern, that basically means you have to unravel everything. Well, and if I say in that situations, hey, you won't get a refund, I don't do this, it's the law, well, I do think that would be a little bit petty, don't you think? Now please, please, please don't go into full-fledged Karen mode and complain that there's a comma missing on page 12 and that is the worst pattern I've ever read and I want to see the manager and get my money back. Stay kind and phrase your complaint in a respectful way. Ask any customer service employee. The second you get loud, the second you use insults and that kind of language, that is the very second they will not move one step beyond what the law requires. Last question. Can I resell yarn or patterns? This is actually the most difficult question to answer for me here. Selling is typically always a commercial activity. You are selling stuff. And the problem is that most countries and even states within a country have a different definition of what compromises a commercial activity that requires the registration of a business. In some places, even the intent to earn money, not the actual sale, but the intent is enough to require a registration of a business. In other places, certain activities don't require you to have a business no matter the extent. One example, here in Austria where I currently live, if I only ran this YouTube channel, I probably, the way I understood it, wouldn't have to register a business. In Germany, back in Germany, I definitely needed one. And also, some countries have certain thresholds. So, say in Germany, as long as I don't sell yarn from my stash for more than 600 euros a year, I don't have to pay tax. In the US, the threshold for collecting taxes is typically around $400, and if you make more than 20,000 US dollars per year, you may expect to receive one of these 1099K forms. But if the customer buys online, so for example on Ravelry, you can actually sell your D-stash, your old yarn. And if the customer resides in states like Oregon or other states where they do not have any sales tax requirements, I think Alaska is one of them as well, well, then you may not have to. So the answer to that question is complicated and something that definitely requires some research. Research how things are not only in your country, that's typically easy, but in your state and possibly even county. And do bear in mind that in the days of the internet, things change rather quickly, and advice that is true, sometimes even only 1 year old, may already be outdated. Also, if you live in Europe, do consider the things like whether you are retired or not, whether you live on social welfare, things like that also matter. But the good news is, in almost all cases, it is possible to sell old yarn or old pattern books, and you don't need a special license like for liquor or drugs. But the question here are the requirements. When it comes to digital patterns, of course, it will be very, very difficult to create a legal framework. You always have to deal with the creation of digital copies, still a big issue for the whole digital world. NFTs, so non-fungible tokens, are first start, but of course typically they are not applied to knitting patterns. I'm not even sure they ever were applied. Now your books and magazines and that kind of stuff can typically be resold without problems at, yard sales or flea markets, and also this could be a wonderful opportunity if you want to knit on a budget. You can always find wonderful stuff there. But if you have a huge stash with yarn worth thousands of euros and you want to get rid of that, well, things quickly do become a little bit more difficult. Now there you have it. Those were the most important and frequent legal questions I received that concern knitters, and some first answers and hints. And one more time, this is important. This video was meant to give you an overview and cannot and can never substitute proper legal counsel, especially as you may see this video at a later time where the legal framework has changed. Also, if you count the times I used could, probably, and typically in this video, one could assume I'm a lawyer, but of course I am definitely not. I am just a humble knitter. Anyway, like this video if you enjoyed watching, comment with your feedback because this video was a little bit different than usual, and don't forget to subscribe to my channel because normally it's all about tutorials, tips and tricks and reviews. Happy knitting and enjoy the rest of your day.